Thank you all for coming back. Although I guess you didn't come back, we didn't let you leave. So we're here to talk about federalism, and it occurs to me that if this were 10 years ago, the federalism panel maybe would have been first up instead of in this after-lunch trough, because, well, no, I was going to say, no, I'm trying to make a rhetorical point, Neil. I'm not criticizing. My rhetorical point being that 10 years ago, in the middle of the Rehnquist court federalism revolution, when the court was going around striking down various acts of Congress as exceeding congressional power under the Commerce Clause or Section 5, kind of federalism was very much on people's minds when they thought about the Supreme Court. And now, although it may be less salient as a kind of standalone concept, as we've, I think, already heard through this morning's series of panels, federalism is everywhere. For example, I mean, I was kind of surprised when I got my notebook to see that the immigration case, the Candelaria case from Arizona, was listed under individual rights, because since that comes up as a preemption case, I mean, silly me, I thought it was a federalism case, and I invited Mike McConnell to talk about it, which he will in his own inimitable way. So the court has a dearth of actual federalism cases on its granted docket for the coming term, but there are loads of federalism issues rattling around, including a couple of the most important issues facing the country. The one that leaps to mind being the whole health care debate about the constitutionality of the new health care law. There, in your materials, you'll see some articles about a very interesting case that came down last year, U.S. against Comstock, in which the court upheld a federal law that kind of reached into the state criminal justice systems and provided that dangerous sexual predators who had finished serving their state sentences could be held under federal law. And the question was, where did Congress get this particular power? There didn't seem to be. The federal government has very limited powers in the law enforcement area generally beyond the reach of particular federal statutes. And the question was, what was going on here? And the court ruled in a very interesting case under the necessary and proper clause. I'll just read when we are determining whether the necessary and proper clause grants Congress the legislative authority to enact a particular federal statute, we look to see whether the statute constitutes a means that is rationally related to the implementation of a constitutionally enumerated power. So there's a couple of contingencies in that holding, an opinion by Justice Breyer that was joined in full by Chief Justice Roberts, rationally related to the implementation of a constitutionally enumerated power. And this, as you'll see in your materials, sent some states' rights advocates into kind of a tailspin, because what was Chief Justice Roberts doing? Signing an opinion that seemed to some people a bit of a stretch. So that was the way the last term ended, with this case that raised interesting implications and obviously tells us that something else is going on at the court beyond the Rehnquist era state sovereignty debates. John Roberts is not William Rehnquist when it comes to state sovereignty, just as I think is clear that Sam Alito is not Sandra Day O'Connor when it comes to state sovereignty. This is not a court with a majority that's hardwired to vote for the states when there's a clash between federal and state claims of authority, but there are a lot of, as I said, contingent aspects to all of this, and I think because they don't come necessarily hardwired to a particular answer, the answers may be quite dependent on the particular cases that reach them and the way those cases are framed. So it occurs to us that there are three general areas in which state and federal claims are going to meet in the immediate future, even if not immediately on this docket. So I'm going to ask, and I won't introduce these people because you've seen them throughout the conference, including our two fabulous advocates from last night's argument. I'll ask Ted Cruz to just lead us off, and I ask people not to kind of present necessarily, a fully fledged presentation, but I think we're all interested in these cases enough to have a conversation about them, but just to lead us off in a conversation about the potential future Supreme Court dimensions of the healthcare debate. I'll ask Ted Cruz to start us off on that topic.
Sure. Let me say very briefly before talking about the healthcare litigation. I agree very much with Linda's opening comment that this court is potentially a very different court on federalism. I tend to be someone who strongly supports federalism, and I will admit I'm quite concerned on this court that losing Rehnquist and O'Connor, they were both individuals who had spent very large portions of their careers in the states. And in many ways, they were creatures of the states. They didn't self-identify as animals of the federal government. And we've got a Supreme Court now where virtually everyone there is an animal of the federal government.
Has Sam Alito ever cashed a paycheck that wasn't issued by the federal government?
And there are lots of, the court hasn't been taking federalism cases by and large, although that may be forced to change by pending events. A small thing we were talking about, but it's I think, a reflection of a shift of attitude. In the Rehnquist court, it was quite common for the Supreme Court to grant divided argument to states. There were essentially two groups of amici that had a prayer of getting divided argument. The U.S. Solicitor General that would pretty much always get divided argument, and state SGs that would often get divided argument. And beyond that, it's almost impossible for an amicus to get divided argument. Since it's become the Roberts Court that I'm aware of, that has happened once. And it was a dramatic shift in a practice of, with some frequency, granting motions for divided argument. The only time I know of is a case I argued a couple of years ago, Kennedy versus Louisiana. And I think in that case, that was dealing with the constitutionality of capital punishment for child rapists. And a number of people speculated there that it was an assistant DA from Louisiana, that the court may have been concerned that they wanted additional help so that side would be presented effectively. But I view that as a reflection of a view that the states are less important. There's not a need to hear from them in a way that in the Rehnquist court there was more of a sense of that.
Ted, have states been asking for divided argument as often?
My last year as SG, which was the 2007-2008 term, there were 8 requests, 7 were denied. Kennedy versus Louisiana was granted. There was at least one that we made, a case called Rothgary, that 5 years earlier would have been routine. It was Rothgary versus Gillespie County. It wasn't a hugely important case, but Gillespie County is a county in Texas. And it was all but routine if you had a local county, if you had the state on the same side, you didn't have the USSG in the case, that would have been granted just as a matter of course. And it got denied, that one surprised people the most because it was teed up in exactly the pattern the court typically granted. And then shortly afterwards, they granted in Kennedy. We almost didn't ask for divided argument in Kennedy because they had turned it down so much that we were like, well, okay, if they don't want to hear from us, we won't ask.
Well, where to begin with the botch that case was, but let's not get into that.
All right. The lawsuits over Obamacare, as everyone knows.
Let's just say health care.
Different people can call it different things.
Let's just call it the
It has a
Patient
name,
Protection Act.
actually, and you would look it up. And
I'll tell you what. Let's agree to disagree. Linda can call it health care. Walter can call it the Patient Protection Act. I'm going to stick with Obamacare. As everyone knows, there have been a series of lawsuits filed against it. The two most prominent are some 20 attorney generals who filed a lawsuit being litigated in Florida federal court, and the state of Virginia has filed another lawsuit that is being litigated in federal court in Virginia. Both lawsuits, and then there's some others as well, but that are not as high profile, have engendered a whole lot of commentary, and they're sorts of commentary on two levels. One is commentary on the merits of, is there a meritorious challenge to the substance, and in particular the individual mandate that people purchase insurance. And secondly, commentary at the meta level of standing ripeness. Is this the right vehicle? Can you bring this lawsuit and even get to the merits? Walter last night expressed his views, which I'm sure he'll elaborate on, that he thinks standing and ripeness may well prevent these lawsuits from going forward, that they'll be thrown out and the court won't take them. I'm not nearly as convinced that that's right. I don't disagree that there are real challenges with regard to standing. Although the Virginia case, interestingly enough, the federal government filed a motion to dismiss, and the federal district court denied that, and in a published opinion went through standing and ripeness and concluded in Virginia, the Virginia legislature passed a statute that was designed to directly conflict with the federal legislation. And the federal district court concluded that that conflict in statutes created standing and presented the Virginia Attorney General with the ability to challenge to determine the validity of the state statute. The federal district court also rejected, aside from standing and ripeness, also rejected the government's motion to dismiss on the merits itself. Now, that case is still being litigated. That was a preliminary motion, but it was at least the first reported decision in the skirmish. The merits question is whether Congress has the authority under A, the Commerce Clause, under kind of A minus, the necessary and proper clause flowing from the Commerce Clause, or under B, the tax clause, is yet a whole separate argument. The Act itself specifies it's under the Commerce Clause. As it got into being litigated and defended, the DOJ has shifted in substantial part to defending it as being under the tax clause instead. What the district court concluded in the Virginia case is that both of those could proceed, and the argument at the end of the day is it within Congress's power to penalize doing nothing and to force individuals to engage in commerce. That is an issue, I think, that has prompted quite a bit of debate and will eventually be resolved. I will say also one final thing on just standing ripeness. At the end of the day, regardless of whether the states do or do not have standing, and the cases are or are not ripe today, there will eventually be litigants that unquestionably have standing. It may be that these cases don't proceed, but there will be an adjudication of the merits of whether this exceeds Congress's authority. So ultimately, that fight is a question about timing, whether we get a decision now that goes up or a decision in 3 years that goes up. But one way or the other, we'll have a resolution on the merits. And at least if it's this court, I think it is a closer call how this court comes out on the merits, but I think there is at least a very significant chance that this Supreme Court would conclude on the merits that the individual mandate exceeds Congress's authority under the Commerce Clause.
The question that jumps to my mind, but I'm going to defer to Walter, is aside from the particular, the formal federal jurisdictional questions of the standing of the states, sort of what's the dog that the states have in this fight? And Walter has expressed a kind of a theory about why the state AGs have been so anxious to jump in, rather than wait for the individual who doesn't want to adhere to the mandate. So I'd like to hear from him on this.
All right, let me start back. First of all, you can do a search through the zillion pages of the Act and you won't find the phrase individual mandate. There is the provision in question that's being challenged is one that goes into effect in 4 years. And it is an amendment to the Internal Revenue Code. It provides that there will be a 2% surcharge on federal income tax that you don't have to pay if you maintain minimum insurance coverage, health insurance coverage. So you don't have to pay this tax if you're over 65 and on Medicare. If you're low income, you're on Medicaid.
Is
if
the
you're
word tax in this provision? Since we're talking about what's there.
Well, it uses the word penalty.
That's the word it uses.
As an amendment of the internal rate, it's a penalty measured by 2% of adjusted gross federal income as part of a federal income tax. And I think you'll find lots of the tax provisions or penalties are put that way in terms of tax on yellow oleo margarine, et cetera, go back to the 1930s. That's why I think the Commerce Clause is interesting for con law classes, but any argument that begins that a federal tax is unconstitutional because is a sentence that needs a strong finish because you're way behind, halfway through you're way behind. But I want to come more to the federalism point because I think it's important. In 4 years, this goes into effect, and you have to have minimum coverage. I think in 4 years, the reason the standing argument is important is that when someone who doesn't want to pay the tax penalty and doesn't want to maintain coverage is going to be a very unattractive plaintiff. A very unattractive plaintiff, because the most popular part of this provision is the single most popular part of health care reform is the provision that says that insurance companies may not deny you coverage for an existing condition or a pre-existing condition. That's the most popular part. And it is absolutely undebatable that you can't have that and not have a minimum coverage requirement. Because no one would ever pay for health insurance because you could just show up when you got hit by a truck or got hit by cancer and said, oh, by the way, I want to sign up for health insurance now on my way to the hospital, and you can't deny it. So that
Walter,
if you're...
help me understand why that would be an unattractive plaintiff, because let me suggest a possible plaintiff to you, and
Okay.
just as a conceivable plaintiff would be a small business person who wants to purchase catastrophic health care insurance. So if that person woke up and they had, horrible
Right.
cancer and we're going to spend millions, they have a catastrophic policy. But beyond that, they have the resources and say they want to self-insure and cover their medical expenses in ordinary day-to-day. And if they don't get sick in the ordinary day-to-day, they want to use that money to invest in their small business and provide jobs. Now, why is that an unattractive plaintiff to say,
Well, because you
Congress
say that
doesn't have the authority to force me to buy
right,
something I don't need and I don't want?
Because basically the people that are, quote, going to self-insure are people that, the largest portion of people who, quote, self-insure, unquote, are going to be people who are not putting away the funds that are going to be there.
Well,
I understand you can find a person. I understand that. I understand that. You may disagree with the policy, but this is different than.
I mean, Heller was an attractive
This
plaintiff
is
for a reason.
I understand. This is different than. People say, well, why can't the government say you have to buy a flat screen television? Well, there's a big difference because we have, both in terms of law, the Emergency Treatment Act, EMTALA, you're required to provide treatment for people. I can't show up at Best Buy and say, my team made it to the Super Bowl and you've got to supply me with a flat screen television. And so I can understand why Congress can't tell everybody to buy a flat screen television. I know. But if I show up at the hospital, you got to take me in. And so I think in the main, the class of people are going to be people who are undercutting, absolutely eviscerating the requirement that insurance companies may not decline treatment. But that's getting into the mess. What I want to get to is the faux federalism point. Which I want to say is that 4 years from now, someone who doesn't want to pay the tax penalty and doesn't want to doesn't have minimum coverage will bring a lawsuit. And they will either win on the grounds that this is beyond the commerce power, or somehow Congress can't use it to raise revenue and to use the revenue power to discourage or encourage activities, which they've done with tobacco, alcohol, encourage you through tax credits to set aside money for college, et cetera. It seems to me that goes back to the 1930s. That I would put in a footnote if I were briefing this for the government that, by the way, you can do it under the Commerce Clause as well. Somewhat ironic to the people that said this was a government takeover of 1/6 of the national economy say that there's no Commerce Clause connection here. But leaving that aside, the question is, nobody has yet been required to pay the penalty or maintain minimum coverage. But state attorney generals have sued. Why? It doesn't apply to them. It doesn't apply to their states. If they had standing here, they could challenge any provision. They could challenge selective service laws, the federal income tax laws, Social Security laws, anything. Now, Virginia has a statute that says no resident of the Commonwealth of Virginia shall be required to obtain or maintain health care insurance. And that is a provision that someone can cite. A Virginian can say, well, one of the reasons I don't have to maintain minimum coverage is that even if it's constitutional for everybody else, in Virginia, it says nobody has to do that. To which the answer is McCulloch against Maryland, period. End of story. But even that, the Virginia provision doesn't grant any rights to the state as a state. The Attorney General and the governor, it doesn't apply to them except insofar as they're residents of Virginia, and they don't have standing because, of course, they have government-provided health insurance, so the minimum coverage requirement doesn't apply to them in any event. This has nothing to do with the state of Virginia. I think it would be shocking for someone who's written on standing the way John Roberts has to let someone come into court who is completely not subject to the law. And there is no federal law that I can imagine the state attorneys general could not just go in and challenge even before it had even applied to anybody in the states if they're allowed to come in and challenge this. That's why I think this is a faux federalism case.
So speaking of John Roberts, and I guess we have the points of view on the table here, does anybody think that John Roberts, student of U.S. history, student of Supreme Court history as he is, wants to be the leader of the court that strikes down this major federal initiative a la the early New Deal court? Is that something that's going to be in his mind just as a matter of judicial self-presentation?
I don't know why not.
Well, I don't know, the legal realism questions above my pay grade, but I wanted to talk, just in exchange with Walter on the standing, because I think it's really more interesting than he lets on. So Virginia has a statute that protects people from being required to buy insurance. That is arguably preempted by federal law. Right? Arizona has a statute that allows police officers to check immigration status upon making a lawful arrest. That's arguably preempted by federal something. I'm not sure whether there's actually no federal law there, but federal principles of some sort. Now, you might say that that these are exactly parallel cases. So the question is, does a state have standing to defend defend its ability to enforce state law in the face of a claim of federal preemption?
Oh, that's great, because they're so clearly different, I think. This is not, the healthcare situation is not a preemption matter. That is to say, state law isn't preempted. It's just not an excuse for not complying with federal law. And the federal law, the federal law operates directly on individuals.
That is preemption. That is, every preemption case is one in which someone cites state law for doing something, and the federal law prevents them from being able to invoke that excuse.
I mean, Walter, why did
No,
you
wait a
cite
minute,
McCulloch versus Maryland?
Yeah, I mean, this is McCulloch against Maryland, but in any event, what's different is the Arizona...
So McCulloch against Maryland, the Maryland says you have to pay a tax,
Michael,
and the bank says, no, we don't have to, because the federal government says we don't have to. Did Maryland not have standing?
Of course Maryland did not have standing. That was the
McCulloch against?
But that's because Maryland sued McCulloch. Maryland sued McCulloch.
So they had standing.
Right.
Yeah,
And if
so they had
Virginia If Virginia said no one in this state is permitted to maintain health care insurance, and they sue me because I have a health insurance policy, then you're like McCullough. But let me go to the immigration thing. The immigration preemption issue is about state officials' action. It's about the action of state officials. State and local government officials are the ones whose actions are being addressed.
And if an insurance company in the state of Virginia tries to force a Virginian to purchase some health insurance, who is going to enforce the state law?
I'm sorry, the question is?
If an insurance company in the state of Virginia tries to force someone to purchase health insurance, which is under the Virginia statute is illegal
Right.
for them to do, who's going to enforce the state law?
Wouldn't that be
The
illegal?
individual in
No, they're
a
going to go
court.
to the state, and the state is going to enforce, the state officials will enforce the
But
state
that,
law.
but that doesn't implicate the federal law at all.
It does because it's preempted.
Well, here's I think the point that you're missing in the
What-
this is would you say it's a state law that said California, nobody in California shall be required to participate in military service, right? It's just and therefore Fred Smith of Oakland, California is drafted and refuses to submit to induction and says, I don't have to submit to induction because there's the California statute. And I think it's he clearly has standing to raise the California statute. It's a no-brainer since McCullough against Maryland, that of course is not a defense. But I don't see why the state of California can go into court and sue the Selective Service Administration.
Let me ask you something,
Because
Walter.
of that statute.
In your hypothetical, would California have standing to intervene in that suit and defend the validity of its state statute?
No. I can
Even
file
though
an
the federal
amicus
rules
brief.
and the state rules require that you notify the Attorney General whenever the constitutionality of a state statute is called into play, and state
I
AGs
don't think that
intervene
I
all
don't,
the
I
time
do
to
not
defend the
understand.
validity
No,
of their laws.
I don't understand why it calls into question the constitutionality of the state statute. There may well be circumstances in which a state
Well, it calls
statute
into question the
applies.
validity. I mean,
No,
preemption
it
is not a
doesn't. No, let me explain why it doesn't. The state statute goes on further and has other exceptions. It has to say, for example, oh, by the way, this exemption doesn't apply to state university students in Virginia who are required to maintain health insurance coverage as a condition of enrollment, et cetera, et cetera.
Statute says that.
Well, yes, that says that. Yeah, they had to create a lot of carve-outs. There may well be circumstances where you're not mandated by federal law to maintain health insurance coverage, and nobody can obligate a Virginian to do that. The only thing that is involved is not the validity of the statute. It may well it may be valid in many circumstances. It regulates, for example, it could well be that people under the age of 18 are not obligated by federal law to maintain health insurance coverage, and the Virginia statute says they may not be obligated by Virginia either unless they're a student at a Virginia college. All you're doing is saying, can the individual who is subject to the federal minimum coverage requirement invoke this law as a effective defense if they're covered? The answer to that, I think, is no, but the individual has the right to invoke it. It just is
Look,
not. No one is saying it's unconstitutional on its face. I'm not challenging. The Virginia law may be perfectly constitutional. It just doesn't, because of the supremacy clause, where it comes into conflict, it cannot excuse someone from complying with the federal law if the federal law is otherwise constitutionally invalid.
I think to get to our other topics, I think we better move on to them. And
I just can't think of any case in which a state has ever been denied standing to defend the constitutionality or legality of its statute.
I don't believe that the constitutionality of a statute is
What about legality?
in play.
You know,
It's already not in play now.
Every supremacy clause case is, in a sense, I mean, it's both statutory and constitutional.
I will get, all right, so 4 years from now, when someone is sued, I'm willing to stipulate that Virginia can come in.
Don't they need standing to do that?
They may be permitted to intervene, but why do they have standing when the law doesn't apply to
They're not permitted to
them?
intervene if they don't have standing.
Actually,
guys, we have to move on to our
Do
next topic.
you think the state, I'll put it to you this way, is it your position, you know how many preemption, you know how many preemption cases are on the docket? 8, right? 8 preemption cases. Are you telling me that 8 states have a right, standing and a right to intervene and appear as parties in all 8 of this term's preemption cases?
That's your position.
I think so. They've never been denied it. I don't really see, that doesn't strike me as remarkable.
And actually going back to
You think that the state can file suit as soon as a federal requirement goes into effect on seat belts? That a state can file suit against the federal government just because it has a different seatbelt law?
Well, look, they'd lose on the merits. I mean, you're giving examples that are clearly preempted, and there's not a good argument. So, but that's different from saying that they don't have standing. I mean, part of the core job of an attorney general is to defend the laws of his or her state, and it seems a fairly remarkable
But I do think
proposition.
maybe Linda's right, we should move on.
All right, I was going to ask a question about whether New Hampshire or
I
Vermont could have come in last term in Wyeth against Levine as of right, but we'll move on to the,
Well, I think it's interesting that Walter wants to rely on standing and taxation, too. I think that the Commerce Clause argument is by far the government's strongest ground in the healthcare debate. I think the tax argument is almost silly in that the statute does not tax. It's not a tax, it's a penalty, and it's a penalty for doing something. If every time the government attaches a penalty to an activity, that makes it a tax case and therefore within federal power, that means they could pass a penalty for me for not, cutting my grass in my backyard and fine me $50 and let the Internal Revenue Code Service collect the $50, and they would have jurisdiction over everything. They can't get jurisdiction over things just because they attach penalties to them. So I think this is a very interesting commerce and necessary and proper case, and I don't know why we complicate it with other arguments. Unless for some reason you think the Commerce Clause is a weaker argument than I would have thought you thought.
so.
I don't.
Don't take that bait. So, so we've talked about,
Let me know when it's safe to come out.
we talked about immigration really throughout the day, and Carter mentioned just in passing the latest immigration case to be decided in the circuits, which could be the first up of the Supreme Court, the Hazelton case from Pennsylvania, which the Third Circuit held that the Pennsylvania city of Hazelton, which had passed a very broad anti-immigrant ordinance, not only with employer sanctions, but with prohibition against landlords renting to undocumented immigrants. I think it makes it a crime both to be the renter and the landlord in that situation, and a bunch of other stuff too, and I guess that's ready for a petition for cert. That's a decided case, and some of the others aren't quite as much in the pipeline. But in terms, and that was a implied preemption case. Obviously, I don't think there's a federal statute on the books. Interested in your thoughts, Mike, about the immigration cases, and then we can know about them around a little bit.
Well, this term the court has an immigration case, I guess almost coincidentally from Arizona. It's Chamber of Commerce versus Candelaria. It's a case that I think was kind of a sleeper and that no one would have regarded as a particularly high-profile matter until the other Arizona case came along, and it's, I think, the similarity between the two that has given it a salience. The Candelaria is about an Arizona law that does two things. One is that it prohibits basically it prohibits lawyers from intentionally hiring unauthorized workers and penalizes them. It doesn't tax them, but penalizes them by revoking their business license, and it also requires them to use the federal system called E-Verify, which is a way of checking federal databases to find out whether a worker is unauthorized or not. there's a very interesting lineup of parties in this case, because the Chamber of Commerce, the Farm Bureau Federation, the contractors, the roofers, all the employers of basically of labor in Arizona, plus all the Hispanic groups, plus the United States are aligned against the state law, which gives it a lot of heft.
And the Chamber's been in all these cases around the country. They're also in the Pennsylvania case.
And it really does go to show the way in which immigration cuts across, the immigration issue cuts across, some of the ordinary ideological lines. In the first instance, this is nothing other than a case of statutory construction. The federal statute already prohibits employers from employing unauthorized workers, but it has its own penalty and enforcement structure. The statute expressly preempts states from adding on any additional criminal or civil penalty, but that exception has an exception, which is, quote, other than through licensing and similar laws. And so the question is revocation of business licenses, is that through licensing or similar laws? And the Ninth Circuit held that the plain language of the statute, and of course it also invoked Black's Law Dictionary and various other definitions of licensing, held that business licensing is in fact a form of licensing, and thus falls within the exception to preemption. By the way, a lot of people like to cite the political complexion of Court of Appeals panels. For what it is worth, this opinion was written by Mary Schroeder on the Ninth Circuit, whom I think would not generally be regarded as anywhere close to the right of that court. Also on the panel was a quite centrist visiting judge, former Chief Judge Walker from the Second Circuit, and a Republican appointee judge. So it's a panel that no one, I think, could describe as being extreme in any way. Now so the argument on the other side of this is that licensing, taking away someone's business license, is actually a more severe penalty than the sorts of civil and criminal penalties that are expressly preempted, and thus Congress it doesn't really make very much sense in light of the seeming policy of the statute to prohibit one set of penalties, but then allow another set that are even more severe. There's also an implied preemption claim based upon the speculation that in some cases the state might draw a different conclusion as to whether a particular worker is unauthorized or not. I think this is actually a very important part of the petitioner's presentation of the case in their briefs before the Supreme Court. The Ninth Circuit responded to this by pointing out that implied preemption cannot be based upon hypothetical or potential conflicts between federal and state law, but has to be based upon actual conflicts, and whether such a difference would ever take place is speculative. The state law, by the way, expressly requires state officials to use the federal definition in doing this. The other aspect of this, the requirement that employers use the E-Verify program is somewhat interesting as well. The Congress debated whether to make consulting the E-Verify program mandatory or not, and for purposes of federal law, they did not do that. And so it's a voluntary system, encouraged but not required at the federal level. And so the question is whether the purposes of Congress are being obstructed by a state making mandatory something that the federal government has made voluntary. I think that the answer to that should depend upon why Congress chose to leave the consultation voluntary. That is, if it did that only because it did not sort of want to go that far, the political costs are too high, then that's probably not preempted, because on the other hand, there's some federal statutes that deliberately leave a choice to the private parties because that choice is itself meritorious from the point of view of federal policy. The best example of that is Geyer versus Honda Motors from, about 10 years ago.
On the airbags that came
the
up
airbag
earlier, yeah.
case, where at least the court concluded that Congress wanted automobile companies to experiment with things other than airbags, and thus for a state to require the use of airbags as being the means of restraint did interfere with federal policy, and thus was obstructed. So that's the case before us. And the thing that gives us commonality with the more famous Arizona case that's coming up through the district court to the Ninth Circuit is an underlying question of the way the Ninth Circuit put it in this case is do we interpret the words of this statute liberally or restrictively, that the preemption exception, liberally or restrictively, and that depends upon whether in general the federal government has mostly occupied the field that's being regulated. And if that were so, it would be, if the court adopted the view that yes, this is basically a matter for federal law exclusively with only small little carve-outs for states, that would be an important straw in the wind for the other Arizona case. The Ninth Circuit concluded otherwise, based largely upon a case from the mid-'70s called Decanas versus Bika, which upheld a state law forbidding the employment of unauthorized workers and holding that was within what would the court said it was, quote, within the mainstream of state police powers, which if the court in Candelaria were to reaffirm that statement, it would, I think, have important implications for the other Arizona litigation.
And Michael, the methodology that you suggest would be applied here to kind of look beyond the plain statutory language to the underlying purpose of the preemption language in federal immigration statutes, that of course cuts across fault lines on the Supreme Court. That makes this kind of particularly interesting.
Well, yes, there are. I mean, we often in law schools like to talk about the difference between a more textually based interpretive method, which isn't necessarily the same thing as plain language, but the principal focus on text versus a principal focus on purpose or consequence. This, I think, is a case where those two general jurisprudential approaches seem to point in opposite directions.
Anybody else want to have a comment on the immigration cases, and then we'll move in our last little bit of time to the interesting marriage issue.
This is one of those rare issues where federalism comes up in defense of a more progressive or liberal position. Sometimes people tend to think of cases as federalism cases only when Jeff Sutton or Ted Cruz shows up to argue on behalf of the states, but actually sometimes states do liberal things that they would like to protect from a federal override, and that's true in the context of the Defense of Marriage Act. There are two provisions of this act, one of which I think is relatively inconsequential, and that is the provision that says that no state should be required to give full faith and credit to a same-sex marriage in another state. I say that it's relatively inconsequential because I think that would have been the case without the Defense of Marriage Act. The states would not have been required to give full faith and credit to other in that area.
Right, she just says it's an interstate matter.
Right, but what really matters for the Defense of Marriage Act is the definition of who is a spouse for the literally countless ways in which spouses receive benefits or otherwise subject to federal laws. Social Security laws, federal employee spouses have all kinds of benefits. Service member spouses, There's a whole panoply of matters.
I think the plaintiffs actually counted them. It was something like 1,400 different federal statutes and programs that have.
Yeah, that's more fingers and toes than I have. How many? 4,000. So what the federal government has historically done in order to decide who is a spouse for purposes of one or more of these 4,000 federal provisions is simply say that that's a matter of state law of the state of residence. So if you're a spouse within a state, the federal government recognizes it. And for example, during the period where some states prohibited and some states permitted interracial marriage, whether or not you were a spouse depended upon whether under the law of the state you were a spouse. So that if you were in one of the northern or liberal states that allowed people of different races to marry, then the spouses were included as spouses. So in that sense, the Defense of Marriage Act is an exception to that, and it provides that for no purpose, for any of these 4,000 statutes, that a spouse can only be a person of the opposite sex, and that otherwise it still defers to state law. So that if you are married under the law of the state of Massachusetts, for example, you're married in Massachusetts, you do not get you're not a spouse for any of these 4,000 federal programs because of the Defense of Marriage Act. I think what's interesting about this case is that there are some people on the gay rights side of the spectrum who would very much like to see the Defense of Marriage Act be the next case before the Supreme Court, not Prop 8 from California. And the reason is that this is a case where the sort of federalism interest is on the same side as the gay rights interest. So, for example, if you think about Justice Kennedy, the justice who was the author of Lawrence against Texas, and who has also been a strong federalism justice, his interests line up on the same side. And he would be asked to say that so the argument would be that the federal government doesn't have a sufficient governmental interest that would justify it setting aside the judgment of a state about who ought to be a spouse, for purposes of that state. So you could literally begin the argument, I think you would begin the argument in the DOMA case in the Supreme Court with something like, may it please the court, 45 states have chosen to limit marriage to persons of the opposite sex, and in those states that are unaffected by the arguments we're making. 5 states have made a different choice. And there is no good reason for the national government to override the choice of any of these states in determining who is a spouse, so that you sort of double up. It would be, I think in that sense, the next best case to go to the Supreme Court to say.
So that argument would leave the federal government agnostic as to the desirability of same-sex marriage.
Right. In this case, if Justice Kennedy voted, it was part of a 5-person majority, let's say, to strike down this provision of the Defense of Marriage Act, it would not result in overriding the judgment of any of the states that limit marriage to persons of the opposite sex. It would only have the effect of saying that in those states where the state itself has chosen to extend marriage to persons of the same sex who are otherwise qualified to be married, in those states they are to be treated as spouses for federal benefit purposes, as is generally the case. There's otherwise no federal definition of who's a spouse. And that seems to be a much easier step.
The extent to which there's no federal definition of marriage is one of the things that really surprised me reading Judge Toro's opinions for the district court. For instance, in New Hampshire, I learned in reading the opinion, 14-year-olds can marry with permission of their parents. And so a 14-year-old couple in the state of New Hampshire, if that still happens today, it may be an artifact of, farm era, gets all the benefits of marriage under federal law as anybody else.
Right. You can get a lot of federal benefits as a middle schooler in states like West Virginia and New Hampshire.
And whereas in other states...
So I'm trying to... Are you saying that it's unconstitutional for the federal government to define the word spouse for purposes of its own benefit program?
No. It would. The question would be, Michael, whether it's a deprivation of sort of liberty or equality to exclude same-sex couples. It's the same, the affirmative arguments are all the
So
arguments.
it's unconstitutional. Well, that's just a replay of the
It is,
basic equal
with this
protection
exception,
argument.
no. It is a replay of the same arguments you would make in the California case, with the fact that the governmental interest in California, its governmental interest is in maintaining the traditional view of marriage, you know, for all the reasons that Cooper argues, right? In this case, the governmental interest side of the equation is simply weaker because Congress, the federal government, not only has not seen fit to have a federal definition of who's a spouse, it doesn't even have one now except for this purpose. So the question would be, what is the federal interest in overriding the contrary judgment of some of the states? If you would say, well, it's an interest in having a uniform federal definition of who's a spouse, we don't have one. It still varies from state to state, with this one exception. So what you have is just on the governmental interest side of the equation, a much watered-down version of the kinds of arguments that Chuck was making in the California case. And indeed, Chuck talked about deferring to the views of the people of each state, et cetera. And that all rings somewhat hollow when the federal law overrides the views of people in, you know, 6 states. And it also just makes it an easier swing. If you ask what the consequence is, a ruling in favor of gay marriage in the California case sets aside the laws of 45 states. A ruling striking down the DOMA provision has only the consequence of extending federal benefits in those states, now 5 in number, that have made their own choice that this is a spouse. So it's just a much less consequential step for the court to take.
You know, I have to say, I agree with Michael's question that
You can't agree with the question.
I agree with the premise behind the question.
With
I
your
think.
implied answer to your question.
My only premise is I was puzzled by what Walter was arguing.
Well,
He's actually explained it
you know,
now, and now I understand.
I don't view this case as a federalism case. If DOMA provided that states, in implementing state benefits, shall provide benefits to same-sex couples or shall not provide benefits to same-sex couples, depending on whatever the federal government decided, that would be a federalism case. That would be the federal government intruding on the authority of the states. You know, I have to say there's sort of 2 ways of looking at the argument. The one is, as Mike's question suggested, that the federal government, in defining benefits, is somehow forced to accede to the state's definition of marriage. And that, I just think, is a very curious statutory argument.
I wouldn't make that argument. I wouldn't make that argument.
Well, then the second argument is the argument against Prop 8. It's the equal protection argument.
Plus,
Straight out.
in the context where the consequences of the ruling are less significant and the overriding of state interest, you could at least as well argue that you're exceeding the state's interest as that you are overriding them when you strike down DOMA.
Walter, do you win without getting something more than rational basis scrutiny?
I've always think that you could, for the reasons that the question is whether mere tradition is sufficient to be a rational basis. If it's not, then I think what you're met with is, you know, what's the harm that the government is seeking to avoid?
Well,
I
for mere rationality, presumably uniformity on this question is
probably
not.
right. I could see that the argument would be for uniformity that you want, if you're trying to decide, for example, where to locate a federal facility, you don't want that to get caught up in the fact that if you locate it in Maryland, say, same-sex federal employees will have benefits for same-sex spouses, but not if you put it in West Virginia, that the federal government is such a contentious issue is not going to want to have lots of politicking and argument over whether you, where you, on both sides, over where
What
you cite a
interest did
federal
the government
building.
articulate in defending the statute in the district court?
It's a very, it's hard to parse. It basically says, we defend the statute because blah.
How did they spell that?
And basically, they say that, I think the argument that you make, that the government can decide it's best on this one question about marriage to have uniformity in the federal rule, rather than deferring to each state as they do for all other aspects of what constitutes a valid spousal arrangement.
And I guess they filed, the government's filed a notice of appeal, I guess, that goes up to the First Circuit next.
Right, one of the things the government's been saying is that rational basis is all that's required because that's the rule in the First Circuit, and that's binding on the district court. So now it gets more tricky because the court can maybe say before the three-judge panel in the First Circuit, it's circuit precedent, so we're not going to question it. The government hasn't yet had to face the question of, do you think that's
to cause tremendous bouts of insomnia and nervous agitation among the Office of Military Commission's prosecution department, because they were terrified that this decision is going to somehow come back and require them to make those detainees available. There is a discovery issue which is related. Defense attorneys are going to want to know a lot of things that the government prefers to keep secret. In civil litigation, state secrets can keep those, can often helps the government suppress that sort of information. In a criminal prosecution where the government has initiated the legal action, there might be a different standard. There are questions of selective prosecution because the who has been chosen for prosecution, who hasn't, who has been released for